Considering Let me start out. Good afternoon. Welcome to considering reconsideration. We have a packed hour and a half to convince you why it's worth your while to take cases at reconsideration. So with no further ado, I'm going to introduce myself. I'm Kate Callery, one of the co-coordinators of the DAP program from the Empire Justice Center in Rochester. And I think most of you know Amelia.
Hi everyone, Amelia Cecilia. I'm also one of the coordinators of the DAP program, and I work out of Empire Justice's Yonkers office.
And we're going to ask the other panelists to introduce themselves and tell them why they love Recons. Tell us why they love Recons. Angie?
Hi, I'm Angie Hale, and I'm a senior paralegal at Empire Justice Center, and I've worked on DAP for over 30 years, believe it or not, mostly supporting the other advocates here at Empire Justice Center in their work. I've done everything from intake to assisting with filing U.S. federal court cases, U.S. District federal court cases. Most recently, I started doing direct representation of clients at the Recon and the continuing disability review levels.
Okay, and Blanca?
Hi, everyone. My name is Blanca Quintanilla. I'm a senior paralegal at the New York Legal Assistance Group. I represent clients at the reconsideration level for initial application medical denials, continuing disability reviews, age 18 redeterminations, and also non-disability terminations and overpayments. And I've been doing Recon since the process started in 2019.
Great. And Haley?
Hi, everyone. I'm Haley Wen, and I work at the Legal Aid Society at the Bronx office. I've been doing reconsiderations for a couple years now. I actually also file initial applications, and those, if those initial applications are denied, I take them to reconsideration.
And so that's great to know. And I'll just say for most of the DAP advocates on the phone, on the call today, the session today, that Haley, you were doing that under a special grant because of course, the rest of DAP is not funded for applications, right? Was it?
Yes, it was under a special grant that unfortunately has ended. So I no longer do applications. I'm just wrapping up my few last cases I have.
Yeah, so it's I think we've heard from you, it's been a helpful experience to take cases at that stage, and it's something many of us would like to be able to do, but the current DAP grant does not permit that. So sometimes people get other funding to do those kind of cases, as Haley did in her program. Okay, next up, we're going to just get a little background on reconsideration from Amelia.
Sure. So that's just some context of what we're talking about with reconsideration, or what we affectionately refer to as Recon, or maybe not always affectionately. It is the first step and a required step in Social Security's appeals process. So with any adverse action or determination made by Social Security, a claimant's first recourse is to appeal through Recon. And sorry, I kind of skipped the initial application stage. That would be the very first level of any claims process. If it were denied, that adverse action would be appealable through Recon. So it's the second level of the claims process, but the first level of an appeal. And it's available in relevant, both in being able to appeal an initial determination, but also any future adverse actions that might take place in a claim. So if the person might be later terminated or the benefits reduced, or if an overpayment was charged, those adverse actions are appealable, and they must go through the reconsideration stage. The next stage would be an ALJ hearing. The next stage after that, the appeals council, which is just a review of any errors that might have taken place at the ALJ level, and then federal court review would be the first opportunity to appeal beyond the agency and through the federal branch. Another type of review is also continuing disability review, which we'll also discuss in brief today. All of these levels of appeal are subject to a 60-day deadline, plus 5 days presumed for mailing from the date of the notice of the adverse action. So why must we go through Recon? It is, as I mentioned, the first step of appeal for all cases, and that would, or all issues, all types of determinations, adverse actions, and that includes both medical issues, disability issues, the question of disability on an initial claim, as well as any non-disability issues. But we here in New York feel very new to pursuing an appeal through the Recon stage after the initial determination, because we didn't have to deal with it for a while. We were part of a 20-year pilot, very extended pilot period with 9 other prototype, what they kind of refer to as prototype states, where we were skipping this step after the initial denial of a claim. So, and that is just with respect to the medical determination of whether the person meets the medical determination of disability, not any non-disability issue. This was something that I think most of us advocates and here in New York and those other states really appreciated, because statistically, Recon was not a very fruitful way to getting approved for many people. The statistics were really quite low for allowances at that stage, and we were happy to just proceed to the ALJ level. This change was really just very frustrating when they did revert us back to the otherwise national system of having to go through this level, because they did it at the end of this pilot without actually having any data to show that this was really something that was the best outcome. And in fact, we as advocates had kind of protested and said that it was not, it did not really serve many clients or claimants at that stage. So few were approved, and that it would have been better to devote more time and money to getting the determination right in the first instance, rather than having this kind of intermediate step, which takes place at the field office level, where the claim was filed, without really doing a whole lot more to improve the quality of that review. But SSA's justification at the time was to pursue something that was national and unified, and so they were reverted all of the states to that to the system of requiring all states to go through that Recon process. One benefit of having it is that there will be some claimants who benefit from having a quicker return, especially faced with really long backlogs at the ALJ level. However, and we've got some statistics on the slide, the reversal rate was really abysmal, 14%, and the processing time 152 days. So that's just still actually extending the life of an appeal. It's not really saving most claimants much time.
So what actually happens at Recon? As Amelia said, it's a necessary evil. You have to go through this step. And what happens is just at the initial application, a claimant goes to Social Security, but then the case is sent to New York State's Division of Disability Determinations. What happens actually across the whole country is that the Social Security Administration contracts with state disability determination services. to actually do the reviews. So we're DDD, it's normally called DDS, but we're DDD. And you'll hear a lot about that as we go through how to win these cases, how to proceed with these cases. There's a citation to the POMS. The POMS, as most people I'm sure will know, is Social Security's internal rules on how everything happens, and they're available on SSA's website. So you can read much more about all these proceedings there. But so what happens at Recon is that the case just gets sent back to DDD, and a different analyst, a different claims analyst at DDD conducts a paper review. And as you'll hear as we go through the proceedings today, there's no opportunity for a face-to-face review or hearing at the Recon level, except when there is. And that's, Blanca is going to talk more about this much later, when you're doing non-disability claims. As Amelia said, these we're covering today, reconsiderations both in disability claims, but also if you're appealing the level of a living arrangement, an overpayment, all what we call non-disabilities, as well as continuing disability reviews and age 18 reviews. And you'll hear about how they also can have the opportunity for a face-to-face hearing. But for most of our disability cases, it's just a paper review, different analyst at DDD. So why should you do these? Well, you could help to increase that 14% reversal rate, which, as Amelia said, is abysmally low. But some people actually, you'll hear from the advocates today, have success at the reconsideration level. If nothing else, it really helps you prepare for the ALJ hearing, helps you really fill out that claim, get the information that's missing so that the file might be more complete by the time it gets to the ALJ. It also helps to encourage appeals by adding in that extra step of review. Some with jaded viewpoints might say it's just weeding out more people. Maybe some people who shouldn't appeal, but there's lots of people who should appeal and they just can't get through the system. It's too discouraging. Another step really throws them. So if you're helping them to do that, it could encourage appeals to go beyond only about the 22% right now who appeal initial denials. And then it can help our DAP numbers. You can win at Recon, yay. You know, you don't have to go through a hearing, even though Recons can be a fair amount of work. You don't have to go through a hearing. You get to count it as a DAP win. And I know that Haley and Blanca and Angie will tell you how much fun it is to do Recons. So that's another reason. And now we're going to get into some of the real nitty gritty of it. I think Blanca's going to start us off here.
Yes, so there's a number of ways to file recons. The preferred method I have, and I think everyone should do it this way, is filing it online. So you go to that link on the slide and you can put in information about the claimant's doctors, medications, all of that. You can also do it on the paper form and fax it into Social Security. And you also have to submit a disability report. I usually represent clients automatically at the reconsideration level for medical denials, as long as they are DAP eligible, which means they are under 65 years of age, they are on public assistance or Medicaid, or they have income less than the 200% of the federal poverty level. There's usually no time for investigation of a case at this stage, which is why I represent them automatically. It allows us to become more familiar with the case if it does go all the way to the hearing level. And also you have a more informed view of the case and the records if the recon is denied and you have to take it further. So if you're helping your client file the recon online, you have to fill out all the parts of the impairments, the medications, the medical providers. And because if you do not put that information on there when you file it, the analyst will just rubber stamp it in less than 2 weeks and deny it. So it's also really good to submit your 1696 with the recon. If you do have some time before you file it online to request medical records, that's a really great idea, to just hold off on filing it before the deadline, of course, but request the records so that you have more time to receive them, and that way you can submit them either with the recon or shortly after, so that they don't just make a decision so quickly. Sometimes it takes 3 months or more, but I've had cases where the analyst makes a decision in less than a week, which is ridiculous. So it really varies. So you never know what you're going to get. So the more records you have when you file it or right after you file it, the better.
Great. Okay. Angie, did you have anything to add there, or we move on?
I just wanted to add, for some people who might be a little leery of submitting the 1696, at this point, you can list yourself as a source, and the analyst will reach out to you for medical evidence at this point. And I've done that in cases where I thought, I don't want to submit a 1696. It sort of buys you a little more time. Once it gets assigned to the analyst, maybe you have some time to do some pre-screening of the case. And that's all I have to add right now.
Okay. And speaking of 1696s, I think we're going to hear from Haley on some of that.
Yes, so if you're going to submit the 1696, once you have it, you'll need to fax it into the Social Security field office associated with your client's zip code. And make sure that you put your client's name and social security number even on the cover sheet. Sometimes it can be a little bit difficult to follow up on faxes. There's a lot of phone issues and there can be a lot of fax issues. So I would wait at least 2 to 3 days after you originally fax it to try and call the field office to make sure it's been processed. And so it's important to have a 1696 because you cannot yourself reach out to the analyst and discuss the client's case without this in. And that's where most of the advocacy occurs, is with the analyst. And so occasionally also there are issues where the field office has a 1696 in, but DDD does not have it for whatever reason. And unfortunately, those issues also have to be solved at the field office. I've had that happen a few times, and DDD does not accept 1696s directly. So you just have to call the field office and tell them the issue they're having, and usually you can get it fixed within about a week or so.
Yeah, incredibly frustrating. We've advocated for years to try to change that with the 1696s, but because of different computer systems that don't meld, it still hasn't happened. But there's an electronic option. Amelia?
Yeah, I think the processing of 1696s has been a source of just major ongoing frustration for a long time. And, no matter how it's submitted, it seems like it's just very difficult to get it into the file. The E1696, the electronic 1696 option was pretty exciting to have heard about. I actually personally don't have a whole lot of experience with it. This is something that we might would be interested in hearing from you all. Since we're a big group, maybe you could drop information in the chat if you have had success and have tips using it. We've heard it could be a little bit, and the link is here for where to submit and how to submit the 1696 electronically via SSA's website. We know that there can sometimes be some issues loading. Some advice has been to try a different browser. That Chrome can sometimes be a little bit easier to navigate and helps avoid having to re-enter password, just depending on which browser you're using.
Okay.
Angie, I think
Was there more on that?
I think
Okay.
Angie was going to talk next.
Angie's going to talk. Yep.
And so Social Security also has what they call the Form 3288. When to use the 3288 versus the 1696. For me, if a client comes and they've already requested a reconsideration and they're looking for representation, I will use the 3288. to try to request the file. And for those people who like to probably, again, pre-screen cases or try to look at cases, although this process does go pretty fast, sometimes it is slow. And sometimes it's helpful to contact the field office and request the file from the field office. You can request the CD, or you can request that they send you an email of the PDF of the electronic file. And it is, I mean, you should request that they send the whole file, not just the medical exhibits. You can ask that they send, exhibits A through F when you do this. You should note that you will be getting a raw file. It will not be an exhibited file. Although we're saying exhibits, it's going to be the raw file that you're going to get. And then, of course, it uses the same password convention as you would access OHO's files. For those people who review files, it would be the same convention, which would be the first 4 letters of the claimant's name and the last 4 of their social security number. And I might also add here that I find it helpful to try to encourage the clients to sign up for their MySSA account, because there's the benefits of that is you can find out what their PIA is, and for the client, they can also keep up, they'll send them updates on the status of their case, then they can log in and see how their case is moving along through the process also.
Good. And Angie, I think you said this can also be helpful when, as often happens, a client doesn't really know what stage of the appeal
And that's
process.
another thing, is if they don't know the status of their case, that will, you can also use the 3288 for that. I see that someone put in the chat that they often charge for things. What I do is that I make sure to put on the release that it is program related and related to the appeal. And so you might want to try making sure that you highlight that it is program related. If you don't put that as program related, they are going to try to charge you.
Good point. And I think, Angie, you're also going to tell us about ERE instead.
Yeah, ERE. You can now, and if they scan 1696 into the right places, you can have ERE access to the folder. You can upload the medical evidence to the client's folder if you're able to obtain a barcode. And at this point, you can also see what medical evidence you may have submitted to make sure that it's there in the file. Because at that point, and you'll, just the point here, you'll have to be enrolled in the ERE and the appointed representative services. And I think that was all that I have for that slide.
Right. It was good news when they made ERE available at this level, which was only in the past couple of years, I think. So I'm not sure everybody's still used to using it. And it was cumbersome at first. But the one downside is that it only includes the E and F sections of the exhibit file. And I know there's been some national advocacy. NOSCR has been pushing for changing that, but right now it is more limited. And there's other issues, Angie, right? With
yeah. The other thing is that the field office should acknowledge that they received your 1696. Periodically, I do get a letter acknowledging that they received it and it's been scanned in. If you don't, I'm not going to go through all of the information here, but here's some contact information. If you have submitted your 1696 and you still don't have access to the ERE, or you're having problems, the analyst is not finding it, this is the recourse that you'll have to sort of rectify that, to reach out to OHO. And again, it's always good to, check the ERE to make sure that the evidence that you submitted is there, both at the recon level, and again, if your case is denied, always go in and check if you're going to appeal to the ALJ level, is to check the case again to make sure that all the evidence that you submitted has been considered in them making the decision. I think we recently had a case where I think it was Doris submitted some evidence to the analyst and it didn't get considered. In that case, we were able to work with OHO to get the case sent back to the analyst
Well,
to consider that evidence.
okay, good point. All right, now we're going to go back to this question of reviewing the exhibit file, yes or no, and then what do you do with it and how do you do it? And we're going to hear from Blanca first.
Yes, so once a reconsideration case on an initial claim has been received from the field office, the disability examiner, this is a person different than the initial person who reviewed the claim. They determine if additional development is needed in the case, and if they do additional development, they will obtain certain things like they will document new allegations or worsening of the claimant's condition, including information that was required before but not obtained. So that would be the things like the function report, work history reports, records requests. They will also contact all the medical sources that have examined or treated the claimant since the initial determination and see what they're able to provide. They will also send unsigned reports in connection with the initial determination to the medical source for signature. Also, a medical or psychological consultant who was not involved in the initial determination will also, if requested, they will review the medical evidence and provide their own assessment, or if they think the medical evidence supports this, they will just affirm the initial level medical assessment. So these are things to look for in the exhibit file and to review. And if you see anything that's helpful, definitely use it for your case. The POMS listed on here explains the case development at the reconsideration stage. So those are things that should be included. They don't always, of course, the rules that apply for developing evidence at the initial level when someone applies also apply at the reconsideration stage. But the analyst will also send medical records requests that were contacted previously, but that did not submit any evidence. But although they submit these requests for evidence from the claimant's providers and things like that, they don't always follow up. I think they rarely do that. And so the evidence is not complete usually in my experience. So it's always helpful for you to make sure that you get that yourself. And we'll talk about that in the next slide, but definitely take a look at that. And then they will also send the claimant for consultative exams. Those are not usually helpful, but in some occasions they will be, and there's things on there that can be helpful, like if the claimant reports symptoms and limitations in their daily activities, that can be helpful even if the examiner stated that there are no limitations. So all of these are things that you can review and make sure that you've gone over to see if there's anything that can be helpful for the case, and see if you can use any of that. You can also, I believe there can also be evidence from prior folders. I think Amelia's
Yeah,
going over that.
I can jump in there. I just wanted to add also, we list here the medical or psychological consultant reviews. And of course, Blanca, those are the employed consultants at DDD that review these files. And you'll see that when you see an exhibit file, either at this stage or at OHO, right? You often see that will be part of what's called the ECAT, when you see the review of how the decision was made. But there are people who are employed by DDD to review the files. But as Blanca said, DDD often sends people out to the famous, infamous consultative examiners, CEs, who actually see the person. And I just want to throw in my plug. It's always been my issue with people who've heard me too many times about prior folders. Social Security has been sort of notoriously bad at ever paying attention to the fact that a claimant might have been on benefits before and lost their benefits for non-medical or other reasons, or they've applied before and just didn't appeal in time. And those files can have really relevant information like IQ scores and who knows what else. Social Security has in the past year updated some of the POMs to put a bigger emphasis to the claims analysts, how important it is to really get that evidence from prior folders. So some of the new POMs are listed here, but it's a reminder of all of you to really ask those questions to your clients, because there might be information that that's already there. And DDD should be able to call up those prior folders. They're all electronic now. They should be able to get them. So that's my pitch on prior folders. And Angie, did you want to mention, I know some programs go about this differently. I think it's often really just more expeditious to take the case at Recon than trying to get the file and figure out whether it's worth it. But some programs do a little more pre-screening. Angie?
Yeah, and it depends. I mean, if it's somebody that's over 50, I might not, do as much, but sometimes I will get the DSS employability assessments. I'll request those as a way to sort of pre-screen whether or not to assist somebody at the Recon level.
Yeah, so it's a kind of I think a call for different programs, and probably in each individual cases may call for different things. Probably everybody handles them differently depending on the circumstances.
And certainly, I mean, being able to do, you might have one set of rules for certain people and one set of rules for the others. I mean, they're not always the same.
But Angie, as I think you said, one way, if people have the My Social Security account, you can at least find out if they're eligible for DAP purposes in terms of knowing the primary insurance amount. Maybe it's just a Title II claim and your program only takes SSI, for example.
Right. And it's something that I've been pushing with a lot of clients lately for them to do the My SSA accounts, because it's helpful. I find it helpful.
Good.
Actually, Danielle, there are a number of comments in the chat, and one of them was about the My SSA accounts, and that's something that Danielle mentions. That it can be difficult for most clients to access with just a phone. So Angie, you do help clients set it up at times.
Yes. I've actually had clients who've come in and I've sat with them and help them set it up.
So Danielle mentions a concern that there might be some notice on the My SSA account that they, would otherwise not receive that they wouldn't get because they're not necessarily accessing it regularly. Is My SSA something that where SSA would be providing the only kind of notice? I didn't think so. I thought that was really just a source for kind of claim status and certain types of kind of reports, but like benefit, printouts and that kind of thing.
Well, I mean, recently I had a client that came in and although they hadn't received the paper notice, there was, indication in their My SSA account that there was something coming from the payment center on the 3rd of the month. So
yeah, and I've seen both. The notice on, like as Angie says, the notice on My SSA, but also the paper notice.
But that shouldn't be considered actual notice, like, should it?
I don't.
Right.
I think
Because
they.
it's really,
I think they.
yeah.
I think they didn't send
So
the
the
paper.
actual notice isn't actually on my SSA, right? It's just the status.
I think you
Yes.
can probably look at the notice sometimes. I have
Oh.
incredibly limited experience with it. so.
Okay. Interesting.
I mean, what I saw was the status and then the actual notice came in the mail.
A couple of other just comments in the chat, like regarding this, what we've just been talking about in this section too. There was one question from Thomas Caruso about whether you could request a second CE at Recon. And I believe that might, or maybe we'll be talking a little bit more about that in sort of the back and forth that one might have with an analyst, but is that something that you've done?
So
Yeah,
I
something
haven't.
oh,
Am I
go ahead.
jumping ahead?
Yeah, okay. I haven't requested it for a second CE. Sometimes they will feel like it's necessary to send them for another exam during the recon, or if they didn't have a psychological exam, they'll send them. But I haven't personally requested for a second exam.
I had one time, I had an analyst who was really great to work with, who actually offered a second CE because he thought it might be helpful. So I think that there is precedent in my experience, at least, for requesting a second CE.
And I know Angie's tried to argue against a CE.
I mean, there's no point in a CE if the person doesn't have any physical issues. Like, what's the point of the physical CE? It's all mental. And so, yeah, I've argued against it.
Okay, was there more, Amelia, or should we move on?
There are a number of other comments about the 1696. I'll just say there are a couple of good tips too, because it is kind of a point of frustration of them getting processed generally, but also that that there's some FOs also in particular who can't manage to do it at the recon level. Sarah has a kind of a good tip about that, which I've heard before, about kind of giving them really specific instructions of the update after transfer, like a UAT in the EDCS. So take note of those acronyms, and that when they're asked to do that, when you're giving them their like real specific marching orders, that often does the trick. So I think that's a good tip. And there's yeah, there are a number of frustrations, I think, just in the processing generally.
Right. And the slide mentions, if I go back here, that you have to tell them how to do their job, right? That it has to be added to 2 different systems. So maybe that's what's coming up in the chat too. You know, that you have to really follow up on it, which is unfair, but yes.
And the other thing is to make sure they scan, I mean, like really making sure they scan it into the right location in the file. I've had that happen where I've called DDD and they were like, oh, I can't find it. I can't find it. Oh, it's in the wrong portion of the file. You know, somebody actually said, oh, it's in the wrong portion of the file. But, you know, then they'll tell me, but you have to call the field office to make sure that they scan it into the right portion of the file. And so.
And by then
Yeah.
they've decided the recon. But
Yeah.
you might be able to get some things done to enhance that recon in the meantime. And Blanca's going to talk about new evidence.
Yeah, so I request all of their medical records for the relevant period. And in addition to that, if you notice that your client might have other issues that maybe have gone undiagnosed, or maybe they have been diagnosed with something, but there's no development on it, you can send for IQ testing or other similar testing if your organization has the resources to do that. So I've had situations like this where one of my clients was diagnosed with an intellectual disability, but there was no IQ testing, and that can be really helpful to make a listing argument. So you can send for that if you're able to. And also you can try to get RFC, residual functional capacity forms, from their treating provider, but always beware of the all evidence rule, because you do have to submit everything, even if it's not helpful to the case. So I always, if I want to send an RFC form, I always speak to, or I'm thinking about it, I always speak to the provider first and just ask them questions about the limitations and their experience with the claimant to see if what they have to say is helpful for your case. And then you can send them the form. So that way you make sure that the RFP form will actually be helpful and help you, whether it's with the listing or with a step 5 argument. You can also try to get third-party documentation like home attendant services if your client receives that, or statements from family members or friends that help them with their daily activities, or even if they were working and were receiving accommodations at work, that can be helpful as well. You can't always get all of this before a recon decision because, like we said, they make decisions sometimes really quickly. So it's still worth it to try to get it for a possible hearing if the recon is denied. So that can definitely help you down the line, even if you're not able to collect everything before a decision is made. And there's a very helpful link here for how to use technology to develop records. So you can access that as well.
Right, that's the PowerPoint that was from a session that we had several months ago on all things tech, and it has some very useful points, not only on developing records, but on many of these 1696 and other issues. So it's there for you from the Empire Justice website. And next, now you've gotten your evidence, so how do you submit it? And that's always not as simple as it sounds. And I think we're going to hear from Blanca.
Oh, I think I'm doing this slide.
Yeah.
So
I mean, I'm sorry. Haley,
it's okay. So as Angie already went over, you can upload your evidence directly to ERE. But as many of you have said in the chat, getting ERE is not always easy. So a lot of the times you're going to have to go forward without it. So the best way that you can send evidence is by fax. You can also snail mail if you really feel the need to. But this fax number that's on this slide is the main DDD fax line. So it goes, so any faxes that go to this number go to all the offices. And so you can fax to this number, and it is like a machine that can handle like faxes that are thousands of pages, I've been told. And I haven't had any problems faxing very large documents to it in the past. So you'll want to put it attention to the name of the analyst if you have it. And then you'll also want to include the claimant's name and social security number on the cover page, just to make it easy for them to know where to send it. And then after you do send in your evidence, I would say to wait about a week before you check with the analyst to make sure that they have everything that you've sent.
Okay. Angie, you said, Angie, you haven't really done much with doing it by ERE either, right? You're mute.
You can obtain, I mean, from some analysts, they will give you a barcode. And then you can upload the evidence to ERE. And then some instances, I've actually got some analysts to give me their fax numbers in their offices where they can walk over to their fax machine and get it. So in some instances, you can get the, if it's a small document, small, set of evidence that you're sending, you can usually get the analyst's fax number to their office.
So next, we're going to hear first from Haley about how do you get hold of that analyst and find out who the analyst is so that you can do some advocacy.
So in my experience, it typically takes, after the date of filing, if you filed online, takes about 3 to 4 weeks for the analyst to be assigned. So depending on when your client has come to you during the process, you might need to start doing this right away. Or you can wait and just call every week or so. So this is kind of our weird little system that we've come up with in our unit for reaching the operator at DDD. So you can call this number. It's the main line for DDD. So this will be the way that you can also dial the analyst extension once you have it. You kind of make your way through the phone tree. You input your own phone number as a bunch of zeros, and then you're redirected to the operator. And you'll just need your client's name and social security number. And as long as the 1696 is in, then they'll give you the name and extension of the analyst. A pro tip here is to also ask for the name and extension of the analyst supervisor. Many analysts I've found are allergic to answering their phones, so you'll definitely want to have that handy just in case.
Yeah, let me just ask you as an aside, when I hear the word phones and social security, of course, you kind of start to break out in hives.
Right.
But at DDD is a separate phone system, I think. Is that right? So they
Yes,
just
I rarely have problems with the DDD phones. It's usually not a long hold time to reach the operator. And, I think one time I tried to call an analyst and for some reason their extension wasn't working and they told me their phones were down. But that was one time, and I've done it like many times and they never hardly ever have problems. It's just getting analysts to pick up the phone. That's the main problem with some people. It really depends though.
Yeah, and I can see the chat now and see that some people have comments and tips more about that.
Yeah, I'm
And
sure there's a better system for reaching the operator, but
I
that's
think
how we
they're
do it.
more expressing frustration, but I think that's worth trying, certainly. And then there's some contact information for when that fails. And I know, Blanca, I think you've attested that in particular, Kim Testa can be helpful, right?
Yeah, so always try to contact the analyst first and see if you can speak to them or the operator, of course. But if you're just having issues with your claim and or with your client's claim and you can't get any help, then definitely Kim Testa is very helpful. And then also other contacts here. But I saw a comment that said if you put the client's phone number in, you'll be directed to the analyst. So that's true, and that has to be the phone number that you put in with the Recon. So when on the online form asks you the client's contact information and their phone number, so it's usually that phone number that you put in with the Recon that will take you to the analyst who's assigned to the case. So you can put that number directly and it'll take you to their voicemail, but their voicemail will always say you reached blank analyst at extension blank. So if you want their actual information, you'll probably just have to go through the operator to do that.
Okay, and Blanca, I know you've gotten analysts' names from the 10-day letter, even though there's a lot of baggage with that, right?
Yeah, sometimes I'll speak to the analyst and I'll let them know I have information to submit and they give me a certain time frame to submit it, and they send the 10-day letter stating you have until this day to submit this evidence. But you can also just call the analyst and let them know I need more time, and also let your client know that the 10 days are flexible and it's not always a strict deadline, because they do get nervous about that. So always let them know that you're in contact with the analyst if you are, or that you're requesting an extension of time. And also sometimes the client will get the notice with the analyst information on it. So always let them know that if they get anything like that, to send it to you or let you know and give you the information so you can have that as well.
And, Haley is also going to talk some more about actually doing real advocacy once you found the analyst and connected with the analyst, and try to really persuade the analyst for a different outcome.
Yeah, so there are many different ways that you can advocate with the analysts. And on this slide, there's just some common examples of things that I personally have done before. So you can ask for extra time to gather medical evidence, especially if you're having difficulty with like a particular provider. In that same vein, you can let them know about any upcoming medical appointments. That can be really useful, especially if they have any new medical imaging, like an MRI coming up, or any new appointments with some kind of specialist for their condition. You can also, we talked about this a little bit earlier, but you can also get CEs ordered. Most of the time when I'm getting CEs ordered at Recon, it's because the client wasn't able to attend them at application. But like I said before, I did have one case where I sent a client back for a second CE. And some analysts are going to be also more open to a more substantive discussion of the merits of the case. They might be able to either tell you outright or kind of hint to you what kind of gaps they see in the file and how those could possibly be filled with things like third-party function reports or some kind of new medical source statement or RFC. In the past, I've had an analyst who went really above and beyond in helping a client get approved and told me exactly what the medical source statement needed to say. In the past, I've also been able to argue a GRIDS case with an analyst, which got the CEs canceled actually, and the case approved like almost immediately. But, you know, I've also had analysts who just order the CEs and don't ever pick up the phone over the course of months. So it really, your mileage is really going to vary. Unfortunately, it all depends on what analysts you get and how open they are to discussing the case with you.
I think Blanca was going to talk a little bit about the merits or not of sending a memo in at this point in the case. And of course, that should say short, not sure. That was my fault.
Yes, so after you receive some of the records you requested and you have a better idea of the argument in the case that you can make, you can draft a one-page letter, very simple and brief, just laying out your 5-step argument. And for example, you can just say, I've submitted the following records to you. The claimant has not engaged in substantial gainful activity since this date. They have the following severe impairments. They meet this listing, or they can be found disabled under X grid rule due to these reasons, and they have not, or they cannot perform their past relevant work due to these issues. So a very short letter that you can submit to them, just to make it easier for them to see that you have an argument and they can approve the case with the evidence that you have submitted. But also, if you don't have the chance to do this and you just speak to the analyst, that can be helpful as well, just to let them know that there's actually an argument that can be made here, and they don't have to, you know, look for more evidence or do anything else to approve the case if the argument and the evidence is already there. So that can be very helpful as well. And yeah, so that's something that you can do. It doesn't have to be really detailed, just a short summary.
And I would guess that that's really good advice, Blanca, because I would think that if you sent in a long memo summarizing all the evidence, no one is going to read it. So you want to get someone's attention quickly. Yeah. I know that Mike Telfer brought up a point about when I looked at the chat about how that evidence gets put into ERE that you send to DDD, that it seems slower and harder than with OHO. And it sounds like Sarah Coverberg has tried to find that out, and no one knows. I don't know if anyone has anything more to do with that. I think the three of you have probably not been doing, is it right that you haven't used ERE as much as faxing?
I typically used faxing more than ERE because I actually just got ERE like very recently. But I have used it a few times, and personally on the like 2 or 3 cases I've had it for, I haven't had any big delays. My biggest problem with it has been evidence being mislabeled and exhibited like with an incorrect label. But maybe you guys can speak more to that.
I haven't used it a lot, so I pretty much stick to faxing.
Yeah, I've faxed most of the evidence. If it's I have used ERE though to upload records. One file that was really large, I didn't want to mail it. It was over 2,000 pages and I couldn't fax it even when I split it up into multiple pieces, but I was able to upload it through ERE, and in a couple of days it was already in the file and it was fine. I don't think anyone had to go in there and do anything, but I have been told also by one of the analysts that they actually have to take some sort of action to put the record that you submitted into the client's file. So there's really conflicting information with that. So I always fax it and it always makes it in. And that's the way that I've always done it.
Okay, that's helpful. And we, the advocates in the state have tried over the years to talk to DDD, and maybe someday we'll be able to do that again to try to learn from them what really the best practices would be that would work from their end. And we'll keep trying for that. But you all do it by trial and error, and it's great to have that information shared amongst ourselves this way. So just switching gears a bit, as we said at the beginning, when you're representing a claimant at Recon, you don't have a face-to-face hearing on the claim, except when you do. And you do have the opportunity for a face-to-face hearing if you're representing a client on a continuing disability review, a CDR, or an age 18 review. I think presumably most people know that all benefits are allegedly supposed to be reviewed every 3, 5, or 7 years by Social Security in a continuing disability review. And for children on SSI, their claims are reviewed when they turn 18, and they'll be terminated unless they demonstrate that they meet the adult standard for disability. So I know a number of programs do take even if they don't take regular reconsideration, they'll take reconsideration cases at this stage, because these recons existed all throughout that prototype period. These were still going on. So people may have more experience with doing these kind of recons than the recon that just was reinstituted in 2019. So for a couple of slides up, there's a link to an article. A couple of months ago, we did a spotlight on CDRs in the Empire Justice Disability newsletter that gives more details about what it's about and who has to prove what in terms of medical improvement. But you know, they are cases, and I think the advocates today will tell you there are cases where you can really make a difference if you show up and help clients at these hearings. On their own, lots of times the clients don't show up, or they show up and don't know what the standard is and will sort of inadvertently admit to medical improvement. So it can really make a difference to appear and help in these cases. They're held before disability hearing officers. They're employees of DDDs. They're not ALJs. They're part of the state agency, the disability hearing units. And claimants at that stage they have a right to representation. They have a right to review the file, to present and question witnesses. They're different though. They're definitely informal. I know Angie's done a fair number of them. They're not recorded. Some rules are different. You don't have the same 5-day rule for submission of evidence as you do in regular cases at OHO. So again, they're informal, but definitely worth doing it. When you've got a CDR or an age 18 review, there are some important things to think about in terms of going through the appeal process. And Blanca, were you going to cover this?
Yes. So SSI and SSD benefits and related coverage can continue during the process of the continuing disability review, as long as a request for review is made within 10 days at each step of the process. So continuing benefits are available through the ALJ decision. So a claimant can elect to receive continuing benefits if you file the appeal within 10 days of the notice or the request. But if you miss the 10-day limit at the reconsideration level and you don't have good cause for late filing, the individual can be put back in pay at the ALJ level, retroactive to the reconsideration decision. And in order to continue SSI and Medicaid benefits during the age 18 appeal process, you also have to file that within the 10 days plus 5 days for mailing. And you can fill out the 789 form for that. But it's worth to note that if you are past the deadline to request continuing benefits, it's always worth it to take a second look at the notice and make sure that it's a proper notice, because you might find good cause in there. I've had clients where the notice didn't inform them that they had the right to receive continuing benefits during the appeal process, and that was good cause to get continuing benefits after the deadline. So you can file a recon within 60 days, but you won't get continuing benefits if you don't have the good cause. And you can also submit the form 795 for continued SSI and Medicaid while the appeal is pending. So you can do it that way, fax it into the local office, make sure it was received and that it will get processed so the client can get paid while they're waiting for the appeal process to be done.
Yeah, this is a really important piece of information. I see that there was a question from Dorothy about whether or not the ERE is available for CDRs. I know we used to always have to try to get the CDs for that, and I actually do not know the answer to that question.
A lot of the times they're paper too. That's the, right. So that's.
Oh,
Yeah, I haven't-
everybody- Mike and Virginia have said, yes, they are. We can get the CDR file in ERE. I'm sorry, Blanca.
Yeah, so my CDR cases, some of them have been paper file, but definitely try to get ERE if you can. And it's helpful if you add in your rep ID to the letter that you send to the analyst. And in your 1696, if you're using the old form, which they still process, because I feel like sometimes the analyst can give you ERE access with that. I'm not sure, but I always include it on there just in case.
Okay, that's a good point. A lot of people may not know about what a rep ID is.
Yeah, so when you register for ARS, Appointed Representative Services, they give you a rep ID when you sign into ERE. Like if you have a regular hearing level case, you can access it through your profile and see what it is on there. And so that's the number that you're assigned as a representative. So you would include it in your 1696 and in the letter to the analyst so they can grant you access.
Great. This is kind of a tangent, to say the least, but it's a particular tangent that Angie loves, because I know she's had some success with this. When you're doing one of these CDRs or age 18 reviews, again, there's information, a little more details on what it involves and what they involve and what they require. But don't forget to consider the possibility of continued eligibility for what's called Section 301. This is the tiniest introduction to 301. Many of you may be familiar with it, but it's a program that protects people who are on benefits, threatened with being terminated because of medical improvement in a CDR case, or age 18 and not meeting the new standard in a SSI kids case. And if they're continuing in a protected, in particular vocational rehabilitation programs through Access VR or through school programs, they might be able to stay on benefits. It's a funny bifurcated situation. You may be in essence saying, okay, maybe there's medical improvement, I'm not going to appeal that. Maybe they're not meeting the adult standard, but here's a way to stay on benefits. Angie, I don't know if you want to add to your experience with it. It's not always easy to find out who's doing what, right?
I just want to just add that, I mean, it's a win for that purposes. So
Oh, there you go.
Continue benefits for that purposes, but certainly, I mean, it's a little work. But if there's medical improvement and you can't make a case for them to stay on benefits, this gives them 2 years worth of benefits.
Yeah, so it's a good thing to remember. And if you have any questions about it, call Michelle Spatafor, right, Blanca? She loves it. And now we're going to switch to reconsiderations that don't involve disability, but involve other types of issues.
So this is also a great topic for Michelle Spatafor, and the topic that we could spend, hours and separate trainings about. It's one where I think we've been doing them longer as a DAP community here in New York, but they are also just very much a source of a lot of confusion and mystery. But nonetheless, we do them. And it is the first level of appeal, reconsideration for all those non-disability events, such as disagreeing with the level of benefit, or the amount of the retroactive award, if there's a termination, or if there's an overpayment. Those are all subject to reconsideration. They are at the field office level. DDD is not involved. It's not, because there's no need for a medical review. And, a lot of the challenge here is just frankly kind of getting them to process it properly. It could be very confusing tracking what you're dealing with, in that when something changes with a person's benefits, there is kind of the action and the proposed action and notice about that. And then sometimes there's an overpayment and a notice of overpayment. And there's the opportunity to appeal the underlying facts of what the action was based on. For instance, I am not over-resourced. And then there's also the opportunity to request a waiver. And so a waiver, is also considered a kind of appeal. It could be confusing sometimes when we talk about appealing, and important to really have in mind what you're addressing, and how you're addressing it. If you are contesting the fact of the determination, or if you're simply in a case of an overpayment seeking a waiver. So this is just the moment where you have to really be sure what you're doing. Most importantly, because with reconsideration, you have that deadline of 60 days to do it. Doesn't necessarily apply with a waiver. So at this stage, filing a recon for a notice of award or any notice, not just necessarily an award or of proposed action, typically. Usually you're not usually contesting an award, but a change in payment or an overpayment. You're dealing with a 60-day deadline. There's always kind of the presumption of 5 days that an additional 5 days from the date is presumed when you've received it. So usually you have 65 days. And in the cases of SSI, an SSI recipient has what are known as Goldberg v. Kelly protections of continued benefits that they can elect if they're appealing a determination that's made, if they're appealing within 10 days. Under the regulations, if you are appealing within that time frame, you can maintain your benefits during that recon period. The policy has actually been changed recently. This is really an important and really great new policy change here in bold. I don't think it's hyperlinked, but this is an important emergency message that we've been talking about and trying to make everyone aware of. This period for a person to request ongoing benefits during their appeal has been expanded from 10 to 60 days. If you add the 5 days for mailing, that's from 15 to 65 days. During that period, for the first 10, so under the regulations, it's still 10 days. So if a person appeals during that period, it's just kind of seamless and it's processed. If it's between that 10 and 60 days, Social Security will presume that the person had good cause for it not to have been filed or received within that 10-day period. They are acknowledging in this policy change that they are having difficulties due to COVID and ongoing, longstanding, and continuing issues managing their workload. So definitely, definitely be aware of this, and that deadline is now expanded basically to overlap with the appeal period of 60 days.
Amelia, can I just ask
Sure.
to clarify something? I think it's related to a question Andrew asked on the slide before. This change is only for the Goldberg-Kelly benefits that are for these non-disability reconsiderations, where you only get benefits through the reconsideration stage. That's where you get the extra 60 days. The statutory benefit continuation, which relates to disability claims, is different and is not involved in the 60 days. That unfortunately is still only 10 days, correct?
That's correct. The EM is not for the statutory benefit continuation. It's for Title 16 only, and it's for continuation. It's for Goldberg-Kelly benefits.
Or just these non-disability claims?
Yes, for non-disability.
And before we move on, there was a question about CDR appeals, if the claimant's liable, if you lose all your appeals. And technically, yes, but I think people probably would confirm that there is a good cause provision for those cases for overpayments that might result if you've made a good faith appeal. And I don't think people hear too often about those overpayments being pursued. But that's probably for another day. But in terms of these non-disability appeals, once you've gotten it filed and gotten your Goldberg-Kelly benefits coming, Blanca's going to tell us a little more about the procedures that go on in these kind of reconsideration appeals.
Yes, so an important point to make is when you request a reconsideration, if you file within the 60 days of the date on the notice, recoupment of the overpayment should stop pending a written decision by Social Security. And you can file a reconsideration on any number of issues, but the waiver is only for overpayments. And using the POMs is essential for waivers because waivers are won through the effective development of the record. So that's really important to know as well. A waiver challenges the agency's authority to require the repayment of an overpayment, and they determine whether they will waive someone's overpayment based on a two-part standard. So they must find that the claimant is without fault of the overpayment, and either recovery of that overpayment would defeat the purpose of the Social Security Act, or it would be against equity and good conscience. And there's also another note to make that they can also find that SSI recovery of the overpayment would impede the efficient administration of the program. So you can request a waiver at any time, the reconsideration, like I said, 60 days, and as was mentioned before, but the waiver can be submitted at any time, and it will stop recoupment as well. But if you only file a waiver, if that's the only thing you request and you don't request a reconsideration, you are admitting that the overpayment exists, and so you abandon the right to say that it does not exist. And it's important also to note that if you file both at the same time, a reconsideration and a waiver, in some instances, it might be a good idea to do both at the same time. I would say very rarely, but if you do both at the same time, you need to be careful because the field office will usually confuse the two requests and they will only act on the waiver without ever deciding on the reconsideration. And you always want to have a decision on the reconsideration. So be careful with doing those at the same time. It's usually better to do the recon first and then the waiver so they don't have that confusion. And then we can go on to the types of conferences that reconsideration half for non-disability cases. And I think that's on the next slide. Unless anyone wants to add something here. Okay, so
Yeah, I just wanted to say, Blanca, right, this slide just sort of tells you who gets what where, what kind of conference you get or not. Right, SSI is different than SSD. SSI, you can get these informal conferences. SSD, you can't. You're only going to get a case review, but there aren't as many SSD non-disability claims. And Blanca talked about the overpayment waivers and what that means for both SSI and SSD. But here, you're right, here is your next slide about the types of cases. Review.
Yes, and I'll go over that in a little bit more, but for case review, you have the right to review the claims file and any applicable law and regulations with a representative from Social Security, and they are required to provide copies of the materials related to the overpayment. In an informal conference, in addition to the case review procedures, you can present evidence and witnesses. A summary of the record becomes part of, or summary of the conference becomes part of the record. And the representative who conducts the conference will make the determination on the reconsideration. You can also bring things like bank accounts, statements from other accounts, letters, and other evidence to prove your case. And then the formal conference, in addition to the case review and informal conference procedures, lets you ask Social Security to subpoena adverse witnesses and documents and cross-examine witnesses. A summary of the record also, or the conference becomes part of the record also. You should always request a formal conference. It gives you the most protection. So that's always a preferred method. And for Title 16, you can have a case review, informal or formal conference, and then a hearing. For Title II, you can have a case review and then an ALJ hearing. But for both, if you file a hearing with the judge, that does not suspend recoupment. So recoupment would start back up again at that level.
Sorry. A couple of people have asked about whether these are being held by telephone these days and actually whether they've been holding them at all during the pandemic. Blanca, do you have any experience with that?
Sorry, before, there's a comment in the chat that says after a case review on a Title II overpayment, they will contact for a personal conference. So that's true. If SSA cannot make a favorable determination on the initial request for a waiver, they must schedule a personal conference. But if the claimant does not appear or declines the personal conference, then you can file a reconsideration on the waiver, and then the next level of review, and then the ALJ hearing for that. So that one's a little different, but that's a little more complicated.
Mm-hmm.
And I'm sorry, what was the question?
Whether they're doing them by phone these days or whether they've actually been doing them at all during the pandemic. And of course, if they're doing them by phone, can you get through on the phone?
Yeah, so I have done them over the phone. They will schedule a time, but usually you have to be available all day because they won't call you at the time of the appointment. And so you'll spend all day waiting for them to call you. And then you'll do the conference over the phone. But it's really important if you do it over the phone to submit all the evidence before the personal conference and also your advocacy letter. Otherwise, if you submit it after the conference, it won't be very helpful. It's better for them to have all the information so they can make a decision on the case faster and also clarify any conflicts during the phone appointment.
Okay, we're pretty much coming to the end of our time and our slides. And I think we all know that even though you've worked very hard at this recon stage, there are cases that the recon request is denied, both in the disability claims, probably maybe more, this is a bold statement, maybe more often than the recon request is declined in the non-disability claims. Do you think that's true, Blanca? That you actually can really prevail on some of these non-disability claims at the recon stage?
Yeah, so once it's denied, I want to know if you get records after the case is denied, you should still submit it, because I've been told by an analyst that they can go back and reopen if the evidence is strong enough to show that they can make a favorable decision with those additional records. But definitely request the hearing within the 60 days after the recon is denied. And then at that point, I would usually do the whole investigation stage and see if we can represent at the hearing level. But if you know that some records that you submitted are not in the file for the recon, this would be a chance to still submit everything so that everything is in there for the hearing.
Yeah, and Angie just mentioned being able to do that, right, Angie? Okay, Amelia, did you have someone to say something?
Sure. No, I was going to say it's great, Blanca, the reminder of requesting like essentially a reopening if you do get something shortly after a decision is just always something to try. It's not always just depending on who you're dealing with, like it's not always going to get you a response. But it is something that can actually, make a difference in flagging something new for them. If you do that, and reopening another topic that's, a whole other training, and is available at other levels of appeal. If you do that, just, never lose sight of that appeal deadline to request the ALJ hearing. If you are waiting to hear back on a reopening, that would be my one advice for that.
So yes, again, if you don't lose at recon, there's still another chance. You get to go to the ALJ hearing, and there are, as abysmal as they can be sometimes, there are better reversal rates at the ALJ stage on disability claims, at least. But I think that people who have been doing this for a while have found that it's worth it. It's worth the time to try to get involved in recon. And before I do forget, I just put into the chat that this, for those people who would like to get 1.5 hours of CLE credit today, if you've been here for the whole time, you need to fill out the form that came in the email that you got from Michelle Peterson earlier today with the materials. You need to fill out that form, and the code is Recon, and you need to submit that back to Michelle with the evaluation so that you can get your CLE credit for joining us today. And with that, anyone want to add anything else, or are there more questions? I know people have said it was helpful. That's great. But I know Andrew was once again talking about the famous Poughkeepsie field office that doesn't do anything. And these can be frustrating. These are cases, Amelia can speak well to this, that can, the non-disability claims that can get lost forever at field offices. And there's no easy solution. Again, Amelia and others have been working hard on trying to make that system better. But, we had our prior sessions recently with the representatives from the Public Affairs Office at Social Security, and keep bugging them. They were saying over and over, please contact us. I don't know how much success you get with that, but I think we have to keep showing them that we've been going to them and trying. I don't know, have you, Blanca or Haley, has that been helpful to you, or?
Yes, I've been recently actually dealing with a particularly difficult field office, made even more difficult by all the phone problems that they've been having. And typically when I do contact public affairs about this, they will ask someone from a supervisor from that field office to call me. so we can discuss the issue and how best to move forward. So that's been my experience.
Yeah, I've had the same experience, and sometimes, they'll call you back, but you're not available, and they won't leave any of their information for you to call them back. So that's really frustrating.
Yeah, I've
And
had
even the
that too.
manager's line. Yeah, even the managers now, they're not answering the phone very rarely. So that's really difficult right now.
Yeah, I mean, the phone situation is just a mess, and based on meetings we've been at recently, not going to be resolved anytime soon, unfortunately. And I don't even know what to say about that, other than really trying to use the email route. I think many of you, I know Jenna Carr has helped people with this around the state. Many of you have gotten the encrypted form of email that was mentioned at one of the sessions that we had around the state with the public affairs specialists. But that may be a way to try to get around the phone problems.
Becoming a secure, I forget it, like this, a secure partner.
Right.
Uh,
Right.
It might not be the right name for it, but it is one of the more effective ways to communicate with them. And it, as Kate said, we could expect ongoing communication problems. Their phone system's not getting resolved anytime soon.
Yeah, I'm not sure that it's going to make the people in Poughkeepsie answer, and I'm not sure what the solution is. I know Melina said that they've gone through public affairs and just keep getting sent back, whereas Michael's finding public affairs in central New York to be helpful. So it's a conundrum that we will keep having to work on, that's for sure. One of the other questions that just came up, Angie, and I think, was it really magic language on the 3288? Program purposes is what you put in?
Yeah, I was going to answer that. I just put program related. You can say program related to a denial of whatever the denial is.
Yeah.
Magic word is
And
program related.
Andrea, Michelle said that a evaluation form will be posted. And Michael Telford did say it's becoming a secure partner. And I hate to do this to her, but if you have questions about it, you might want to reach out to Jenna Carr at our office.
One more point about the 3288 form and the charges for the records. I believe the language actually is in the instructions on the back of the form. So, you could, if they're in front of you, you could kind of wave it in their face. It's on the back of the form itself. And so you could reference it there as well.
And further questions, make sure you go to those first three names. But again, thank you all for participating. The code for CLE is Recon. There will be an evaluation form. I can't thank Angie and Blanca and Haley enough for the being here today, but also more importantly, the time they put into preparing for today and really identifying the issues and coming up with solutions to some of the issues. So thank you all so very much. And we'll see you again at another event in the near future. Is there anything else? Okay, thank you.